Member for Vancouver Hastings.
Honourable Speaker, and I think I'll probably go a little bit over my 30 minutes, so I'll let you know that I am the designated speaker. Honourable Speaker, I'm pleased to have the opportunity to stand and speak to Bill 9, the Workers' Compensation Amendment Act. This is a piece of legislation that, as the, the Minister says, was generated and created because of what became clear, what I would suggest are the pretty deep and structural weaknesses within WorkSafe BC that tragically became evident with the two mill catastrophes, the Babine and the Lakeland explosions that led to 4 deaths and 42 injured workers. Honourable Speaker, the bill does move to address a number of issues that Mr. McAtee identified in his work, and it certainly does go some way in dealing with those issues, and I look forward to talking about those specifics in more detail as I make my comments today, and also to talk about some of the areas where we believe that there need to be some improvements in the bill. And there are a number of pieces of the bill. There are a number of aspects of this legislation that are enabling in their approach. And as we all know, Honourable Speaker, that enabling legislation, the devil is always in the details there. And in this case, as I understand, those regulations that will flesh out Bill 9 will in fact be prepared by WorkSafe, and it will be their initiative, and they will do that work. But I look forward, when we get to the committee stage, to talking to the Minister about what her expectations will be for that regulatory regime, and also to talk about the assurances that the process of preparation of those regulations are inclusive in terms of consultation, transparency, and accountability. So you have a regulatory regime at the end of the day that you hope all of the parties to this can say is fair and balanced, whether people get everything they want or not, that everybody will accept that the regulatory regime will in fact enable the objectives that the Minister spoke about in her comments. And that obviously is a piece of work to come down the road, and we will continue to pay attention to that. Honourable Speaker, as I said, that the impetus for this, as tragic as it was, really was the result of the two explosions at Babine and Lakeland. And the result of that, as we know, was that on January 20th at Burns Lake, Babine exploded. Both of these determined through combustible dust. Babine exploded on January 20th, 2012. Two workers were killed and 20 others were injured. And then just a couple of short months later, on April 23rd, in Prince George, a second explosion at Lakeland, where again 2 other workers were killed and 22 workers were injured. When those accidents happened, tragic accidents, WorkSafe went in and investigated. And what WorkSafe found in that investigation, at their investigation at Babine, they found a dust collection system that was ineffective. They found inspection and maintenance systems that were ineffective. They found waste conveyors that didn't adequately capture dust, and that the supervisory staff at the mill did not adequately monitor, clean up, or maintain the mill in a proper way to be able to deal with those risks related to dust. Lakeland, the explosion a couple of months later, it was a very similar situation in terms of the WorkSafe investigation. Dust control measures were deemed to be ineffective. The cooling fans weren't regularly inspected or maintained and didn't function properly. And the supervision was again inadequate in terms of cleanup and maintenance. WorkSafe deemed and determined that both of those accidents were preventable, and that both of them could have, with proper oversight, proper investment, proper cleanup, there was not a reason for either of those tragedies to have happened in the way they did. They forwarded that information on to the Criminal Justice Branch after their investigation in order to have the branch determine whether charges related to negligence or other legal factors were available. And as we know, the Criminal Justice Branch rejected the consideration of charges as the WorkSafe inspection and investigation rendered much of the information and evidence inadmissible in a court because of the way that the evidence was collected. And the reality is it's not that WorkSafe did, the challenge here for WorkSafe, of course, is that the process, the due processes required under the Criminal Justice Branch were not ones that are followed by WorkSafe when they are doing a regular investigation. They are different processes. And what we discovered, of course, is that there was this situation where most of us, I believe, think that this deserved its day in court, but that's not to occur. And of course, we know, Honorable Speaker, that while this is a very high profile and a very disturbing situation with these two explosions, and we will talk a little bit more about that. What we do know as well is that they are not entirely unique. The laws, we can go back and reflect back to the Westray Law, which was a federal law that was changes to the criminal code following an explosion of the Westray mine back in the Maritimes. And the result of that was changes to the law to create the opportunity for charges, criminal charges, to be laid against a company if there was negligence that was deemed to be preventable, and charges against senior officials and executives with those companies. But what we know is that law, which was adopted decades ago, has never ever been used. And it had not just in British Columbia, but it has never been used in the country. And you need to ask yourself, when you put a law in place that no criminal justice branch anywhere in this country has the ability to use, what you're facing. And that's the circumstance that we faced here. And that is the criticism that has been made by advocates of worker safety and across the spectrum. And they have challenged what occurred here. Honorable Speaker, we know that the weaknesses and the situation that we faced here was very tragic at both Babine and Lakeland. We know that there needs to be a resolve to this. We have had debates in this House and questions in this House and discussion about how the government should have approached Babine and Lakeland to get to a resolution. The government clearly, Mr. Dybel, as was reported, did his work. That was followed by Mr. McAtee doing his work, the work that he continues to do at WorkSafe. And we know that this has been an issue that I think the minister no doubt has paid a lot of attention to, and I think that some of the changes that we're seeing, I think the placing of Mr. McAtee at WorkSafe is a demonstration of that. I think the president and the CEO deciding it was time to retire is an example of that and is partly motivated by that. But I still think that there is more that needs to be done. And this legislation will afford us the opportunity to speak a little about that, and we'll talk more about it when we get to another process around estimates here sometime in the coming weeks. But as the minister knows well, the coroner's inquest that has been followed on one of those incidents, the Lakeland accident, which is in play now, and the minister will know, Honourable Speaker, and the House will know that we've been called, and we called for an independent inquiry, not an inquest. that we wanted an independent inquiry. We wanted the families and the workers and the victims to have the resources to be full participants in that inquiry. That has not occurred. We have the inquest, and we have had a situation where the inquest was proceeding with a number of parties who were quite rightly part of the inquest, whether it was the company, the union, WorkSafe, the BC Safety Association, a number of people who have vested interest, and of course the coroner's own legal counsel. So we had an array of lawyers there. The families didn't have the legal counsel that they desired and that we believe that they should have had. The other thing, I think it was our view, is that the inquest had limited ability and has some limited ability to deal with some of these questions. We now, as we all know, the inquest has been adjourned at this point. It was adjourned by coroner's counsel, and that adjournment came because it came to light that the company had a company do their own investigation of the accident, a forensics company out of Seattle, which did their own work and produced what we understand to be a fairly detailed report around this that the coroner was not aware of. They did not have knowledge of that report, is what the coroner's counsel, Mr. Orr, has said. And he adjourned and requested and got the chief coroner to adjourn that inquest at the point where it became evident that there was this body of evidence. It also became clear at that time, as Mr. Orr has stated, the lawyer for the coroner's counsel, that apparently WorkSafe has had knowledge of that report from the company for 2 years, is what Mr. Orr had stated publicly. And that WorkSafe did not disclose that information to the coroner. They didn't disclose that information at all. That's troubling. That's troubling that that didn't occur, because what we would expect, and I think as the minister had said in response to questions here, and it's correct, is that if the intent of that inquest is to find the answers to the questions, then you would expect and hope that all parties would in fact be contributing to those answers. And it becomes particularly troubling when the major public body there, responsible for public safety, for worker safety, for protection of those workers, and for these investigations, in fact, was aware of information that they did not disclose when it became clear to them that others were not aware of that. That's a problem. I know the minister, I think, was up to the inquest. I've been to the inquest on a couple of occasions to sit and listen. And what I heard here was what you hear when you put 6 or 7 or 8 lawyers representing different bodies in a room and put witnesses on a stand. Those lawyers do what they do, and they protect the interest of their clients, whether their client be the company or the union or WorkSafe. And that's what they were doing. And this was not necessarily the environment to find, I think, the answers that we needed and want to find. The result, though, of the matter with this report from the company that now has come out, of course, it led to an adjournment of the inquest. That adjournment, I understand, the inquest will reconvene on the 11th of May, and there will be evidence given by the authors of this report for the company, and I'm hopeful that at a minimum, WorkSafe representatives will follow that with an explanation of why they didn't disclose this, and what has been suggested in the media. I've not spoken to folks at WorkSafe, so it's what I read in the media, that they also declined that information when it was offered to them by the company when they were doing their own investigation, that WorkSafe declined the forensic report. And if that's accurate, it certainly raises a question about why on earth they would decline that information. It may have been totally appropriate for them to take the information, to review the information, and to determine that it didn't have value. If they had done that, that would have been fine. I could accept that, but to decline it out of hand raises a serious question. So we have this problem. So what you have here now is this other situation with WorkSafe, where there's a cloud hanging over them in relation to why on earth would they make that decision to not disclose critical information that they had, and to have not even reviewed the information when it was offered to them from what presumably is a credible company that did this work on behalf of Lakeland, the mill. The result of this is, at this point, you will know that the union, the steel workers who had representation there, have made the decision that they believe that the inquest is now fundamentally flawed, and they have withdrawn from the inquest at this point. That's a problem, because while the workers, the families and the workers have no representation there, and I know that the minister has said that's the responsibility of the coroner's council, and I understand that. But as an example, I would note that at the day when I was there for the opening day, and one of the gentlemen was a long-time employee of the company, was up giving testimony. He, of course, was asked to review a number of photos, a number of pieces of evidence that he had not seen prior to coming on the stand. And if the coroner's counsel, and those requests, the coroner's counsel is the counsel who took him through those documents. I would have anticipated if the coroner's counsel was acting on behalf of the families and the workers, the victims, the workers who survived, that there would have been some time to sit down and to have given this gentleman the opportunity to see and review those materials prior to being asked to comment on what those photos were and particular aspects. So that's problematic, and I don't think there was anything malicious about this, but it just is it is a problem, it is a deficiency in that process, because those families and those workers don't have counsel that represents them. They don't have anybody who is committed to ask the questions that they want asked and to get the answers that they want. So that is problematic. So we have that situation. One of the things around the accidents themselves that motivated Bill 9, this particular piece of legislation, and this gets to, I think, what has been talked about as some of the structural weaknesses that have been exposed at WorkSafe BC here. There appeared to be clearly, and I think the evidence was showing that there were clear inefficiencies, as WorkSafe identified in their review, around conduct and around the adequacy of how they addressed a number of items to control dust. But the levels of combustible dust were there. There didn't appear to be any prior enforcement from WorkSafe BC to deal with this. There was a failure to identify those hazardous levels of combustible dust ahead of time, and there, of course, wasn't enforcement. And this is particularly concerning in the Lakeland situation. Babine was, a shock to everybody when it happened in January, and that's, we all understand that. But the day before Babine occurred, as we heard in the testimony at the inquest, the day before there was a major fire at Lakeland, including a fireball that went 30 feet into the air, and a major effort by all of the workers at the mill at Lakeland to get that fire under control. We were told by one of the senior operators there of the head rigs that they said only one of the two head rigs was operating, and that's the reason that they don't think they had a full-blown explosion at that time. If both of them had been operating, the amount of fuel, the situation would have been different. So this occurs the next day after that, the Babine explosion. And the question you have to ask yourself is, at what point here does there have to be a report on that Lakeland incident, the accident, the fire, knowing that there was an explosion the next day? And how is it that there weren't WorkSafe inspectors all over that mill almost immediately to ensure that we weren't looking at a comparable situation to what happened at Babine. But there weren't. There weren't. And that's troubling. That's troubling however you cut it. So, Honorable Speaker, we have this challenging situation as we see it there. It's particularly challenging for the families and for the victims. I'm sure that the minister has spoken to the families and to the workers, and she will know. I certainly know from discussions I had with some of the workers there that they are far from recovered from this, and who knows whether they will ever fully recover. Not only from the personal trauma, but the reality as well that I can see in their eyes as they said, talking to one of the workers saying, I worked for 30 years, 25 years with Glenn Roche, one of the gentlemen who died. And I'm not quite sure why I'm alive and he's not. And there will always be that feeling. He talked about how when Mr. Roche was brought out of the explosion, the terrible shape he was in, and the struggles they had to get emergency vehicles in to be able to get Mr. Roche to proper medical facilities, and how eventually, I think it was a fire warden or superintendent who took Mr. Roche in his own vehicle to get him to try to get him some care. And obviously, sadly, he succumbed. But the families, they are not feeling confidence about this process at this time. And we all have to stay aware of that. And there are regulatory processes, there's independence of the inquest in the coroner's office, and we all have to respect that. But we also have to respect the families that feel pretty alone in this whole process today. And there's them and the victims who are other workers who feel alone in this process. And I'm not sure that we are paying as much attention to that as we need to. So, but Honorable Speaker, that all resulted in, as the Minister says, the McAtee work. And McAtee's report, the WorkSafe Review and Action Plan. And that WorkSafe and Review and Action Plan led to a number of things and led to Bill 9. And what we know in Bill 9, as the Minister said, it deals with a number of factors, but it deals with some critical 4 or 5 core pieces. It introduces a new compliance agreement system where employers who violate the Act can promise WorkSafe that they will fix the problems, and at that point, with the proper commitments, escape a fine or an order at that time, providing they proceed. That's a good thing, but what we're going to need to talk about when we get to the committee stage is what happens if they don't comply, because there aren't specific consequences addressed in the legislation itself. These are consequences that presumably, if they're there, will be addressed in some regulatory process, in the regulatory regime that will complement the legislation. So the challenge for us will be to try to draw out, and I'm hoping the Minister will be able to talk a little bit about what her thoughts are and what the scope of those consequences are for a company that makes a commitment on a compliance agreement and then chooses not to proceed in a full and thoughtful way to fulfill the objectives of the compliance agreement. The bill encourages on-the-spot ticketing, as the Minister said, of up to $1,000. Now, in my understanding, that's different from administrative fines of $500,000 or plus or so, but this is presumably the opportunity for a WorkSafe inspector to get somebody's attention by writing them a $1,000 ticket in the hopes that that gets their attention to actually proceed with some action. It's for a large company, it's obviously a negligible price, but we will have to ask ourselves, and we'll have this discussion, about how the $1,000 amount was arrived at and why the government and the minister anticipates that that becomes a reasonable deterrent or punishment at the early stages. Obviously, there's the bigger fines down the road if you come to those. But why is that a deterrent or a punishment if it's deemed by an investigator that that's necessary? The legislation also talks about stop work orders and injunctive powers that have been expanded to allow WorkSafe to go after employers who continue to ignore or breach WorkSafe rules. Some people would have called this the Arthur Moore clause. For those that know, Mr. Moore has a long history in the asbestos removal industry of hiring people, providing no protection or security, changing his companies on a regular basis, and has a long history of exploiting workers around asbestos removal and acting in an irresponsible way. And we know that WorkSafe was never able to get at him. They got at him on a contempt of court charge. They've never been able to successfully charge him, have him charged, or in any way be able to act on him until they finally were able to get a contempt of court ruling because he ignored the courts. That's as close as we've got. So again, there's a whole piece of regulatory regime that relates to this and the effectiveness of the tools that will be required to make this piece stick. I think it's an area that everybody would agree is a good idea and it's a good clause, and the question simply is going to be, can it work? Can it be made to work, and can we be assured that there aren't loopholes that allow people who act in an irresponsible way to get around? Those people that every legitimate and credible and thoughtful employer in an industry wants out of their sector and out of their industry because they just give people a bad name. And I know that people who work legitimately, for example, in the asbestos removal and hazardous waste materials area would be happy to have Mr. Moore long gone from that sector because he does nobody any favors. The other is, and the minister spoke about changes to the board of directors. And the board of directors are changed under this legislation by adding 2 new directors. One of those directors, somebody with occupational health and safety experience, to add to the list, and the second with a law enforcement background. Nothing wrong with these changes. It will be hard to know how they in fact enhance the board, and we'll have to have some discussion about that. There are a couple of areas that I guess I would note at this point, and again, the minister would know this. We have suggested on this side of the House that there needs to be a stronger relationship, and I know the minister talked about a memorandum of understanding with the criminal justice branch, but we have suggested that a dedicated Crown prosecutor makes sense, somebody who specializes in the field of employment law and occupational health and safety, and can provide direct advice to WorkSafe in proceeding with initiatives and investigations, and also can support making sure that the best practices are in place to allow that if charges are warranted, they in fact can go ahead. There may be a number of ways to get there. The decision was not to do that. I believe that's something that Mr. McAtee, who wrote the report, had some sympathy for, a position that he had sympathy for, but it hasn't occurred. The second area, and it relates to the board, and we'll talk a little bit more about this as we proceed as well, is concern that has been raised to me that there's one workers' representative on the board who is appointed to the board. The concern is that there's not a lot of worker representation. And it was pointed out to me, and I know it can change depending on who the appointees are, but the public interest appointees are, appointee is somebody who comes from an employer side background as well. So it would be good, and maybe the occupational health and safety position is a position that it would make sense that come from somebody in on the employee side of things, the worker side of things, who brings special expertise. And as I'm sure the minister knows, because she's spoken to lots of people at the Federation of Labor and others, there's no shortage of people on the employees, the worker side, who bring particular expertise in the areas of occupational health and safety and could be a good contributor to the board. So we might suggest that would be a good place to at least put a second member on that board to deal with those matters. The other thing that the legislation does, the other of the key components, is that the bill requires 2 accident investigations to be addressed with reports. One within 24 hours of the accident and one within 30 days. This is the problem here, and I think the 24-hour one makes some sense to quickly have the company do an assessment. But there is a question here about whether WorkSafe is downloading its regulatory responsibilities on that broader, more comprehensive investigation. Some of the areas where there is difficulty and where we've seen difficulty in a number of areas, I believe, with where the government works, we see this in the environmental side sometimes, is around self-policing and self-regulation areas. And some of the concern that has been raised to me is that second investigation begins to look like self-regulation. And the question is, why isn't there an independent third party with expertise, like WorkSafe, conducting that second investigation? So we'll get a chance, hopefully, to talk about some of that in committee stage as well. We'll get to talk a little bit in a little while about some of the things that aren't in the report and some of the other challenges that we've seen with WorkSafe moving forward. Some of the key issues that we've seen here as we move through, and I'd like to talk a little bit about some of those issues and some of the sections of the bill. Again, Section 1 of the bill, and this is one of the areas that is pretty key, and I referenced this a little bit earlier, is around the notion of injunctions and the ability to injunct employers and prohibit employers and their personnel from carrying on business if they failed to pay fines, they've contravened the act or a WorkSafe order, or they've continued to be problematic. That probably works pretty well if the company has few assets, it's a smaller company, and depends on its principal, owners, and officers. And if you injunct them, then that could help to slow down their ability to do business and get their attention, hopefully, to in fact comply with WorkSafe's rules. However, a lot of people work for very large corporations. They're not in danger of closing. They just set up shop elsewhere. For example, neither Lakeland or Babine owners, neither of these are fly-by-night companies. They're both well-established companies. And you need to ensure that if these powers are going to work, that they be able to dig deep enough that they actually have an impact on a company like that, a larger company, if they choose to ignore or not properly adhere to WorkSafe orders. Because as we know, what happens with large companies and small companies can be very different. And you need to make sure that you're protecting the integrity, or you're protecting the integrity of the law and of those injunctions if in fact you're dealing with a larger company. Again, the second, in Section 2, deals with the Board of Directors. As I mentioned, you're adding these 2 new positions to the board. It raises questions about why the decision was made, and I'll look forward to the minister's explanation about what she believes is the improvement that comes with these 2 positions in the sense and necessarily as how they are. They do begin to raise, I guess, some questions about how WorkSafe works. And this is probably where we need to have a better and a more independent review at some point of WorkSafe. And there are questions here when you have this one entity, which is as complex as WorkSafe is, where it's supposed to write the rules, because as we know, because of changes that were made earlier in the 2000s, the Board of Directors now has essential legislative authority to write regulations, to do things that for most everybody else in government are done by cabinet and by order in council. In the case of WorkSafe, they get to write their own regulations. Very different situation than everybody else. So they get to write the rules. They have to ensure that the rules are followed. They investigate and fine employers who break the rules. They're supposed to compensate injured workers, provide vocational and rehab services to those workers, and deal with prevention matters. And they do this all at the same time. These are a whole lot of roles, and there has to be some question. Even though there are a fair amount of resources at WorkSafe, no doubt, they've got $11.5 billion of investments, as I understand. So they got a lot of resources, but there is a question about whether the complexity of the organization is such that it needs some review as to how it works. And that probably requires more than adding 2 people to the Board of Directors. So it's a challenge. So we'll look to, and I certainly have no qualms about somebody with health and safety expertise and somebody with legal expertise sitting on that board. That makes fine sense to me. But whether that actually is a fix for the governance issues at WorkSafe is an entirely different question. And it's not a question that I believe gets answered by adding a couple of directors to the board. The other area here is around appeal deadlines. And these are minor amendments to the procedure for appealing WorkSafe decisions. They enable the government to shorten the time limits applying to appeals for their orders. The problem is that you need to have a pretty assertive approach to the issuing of orders and fines. With Lakeland and Babine, as we know from the report that WorkSafe did post those accidents, that they didn't deal with dust issues. That was acknowledged. They didn't deal with proper maintenance and upkeep of equipment. The supervisory staff didn't do what they needed to do. WorkSafe identified in both cases that these accidents were entirely preventable, yet they never were in those places to issue those kinds of orders and fines, at least orders, if not fines, that would have triggered any question around appeals. So an appeals process is good, but you need a system of enforcement in place that works before you concern yourself with appeals. And there continues to be questions around that. I know Mr. McAtee is working on that, and I'm pleased that he's working on that. And maybe we'll see more about that as we proceed. But it is an issue because clearly that side of investigation and enforcement has been lacking. It has been lacking, and we need to address that. The question of the compliance agreements, again, just to come back and reflect on that, there needs to be a role for enforcement and compliance agreements. We need to be able to ensure that there's a requirement to comply and to see what happens there. We need to get a better sense, I believe, of a number of those key pieces, whether it's how stop work orders are going to proceed, how ticketing will proceed, how the administrative penalties will proceed. And all of those are things that I believe that we'll be able to hopefully flesh out to some degree in the committee stage. So we have this situation where we are today, and the question then becomes, what happened? What happened at WCB, Workers' Compensation Board, still WCB to me, but at WorkSafe? that created this situation. Honorable Speaker, we know that when WCB was created back in 1917, it really was the historic compromise. And this was the compromise where no-fault compensation is put in place for workers to ensure that they were protected, they were compensated, to ensure that there was some protection around workplaces. And in return for that, litigation was off the table, and there were court case after court case around accidents. That makes sense to be able to do that, but to do that, WorkSafe has to play a bigger role than it has put itself in recently. I've had people who are in the sector who would say to me that WorkSafe has become a glorified insurance company for many, and that has been its focus. Whereas we know the focus needed to be fair compensation for workers who are injured to ensure that they can continue to support themselves and their families, proper rehab and vocational training to allow them opportunities to get back into the workforce, whether it's in their original place of work or if they have to change their occupation to ensure they have the ability to do that and to move into their occupations. An aggressive program around prevention to ensure that you protect workers and you hope that they get home when they need to. The problem is that we have seen a number of changes that don't help with that. A number of things that have happened around this, Honorable Speaker, and some of these relate to areas that are covered by Bill 9, but some of them also relate to the broader challenge around WorkSafe that is reflected in the problems I think that Bill 9 is intended to fix. We've seen the effect of the elimination of many of the pensions that people get, and compensation obviously is a huge part of what WorkSafe and WCB provides. We've seen a reduction in vocational rehab assistance for injured workers. That's a problem. The appeal processes have become incredibly technical and litigious. I know about other members here, but I know when I get people who come into my office with WorkSafe issues and WCB issues, we are very, very careful. We're sending them to workers' advisors. If they're unionized, we're sending them back to their unions to get assistance because they're so complex, these cases. And the reality is, if the appeal isn't handled exactly right, they lose that opportunity. They're done. And what could be worse than somebody who goes to work, is doing their best on the job, has an accident that is not their fault, and all of a sudden their life for them and their family is turned upside down because of the complexity and the technicality of a process that they can't get their head around and that they can't get the support for. And we need to figure out how to fix that and remind ourselves of what WorkSafe and workers' compensation was supposed to be all about. I mentioned pensions before, and we know there are real issues about what happens post-65 with people who had lifetime pensions and lifetime pensions that are not there now. There are issues about the value of that compensation and changes in the value of the compensation. You know, it used to be before changes that started in 2002. It was in 2002 that there were a series of legislative amendments that were proceeded with. You know, they came as a result of Alan Winter, who was an employer-side lawyer on compensation issues, who was brought in by the government to in fact rewrite the rules, and he did that. And he suggested a number of changes that very much, you would argue, were supportive of the employer's side. And that included changing how people are paid. You know, it used to be that folks got 75% of their gross income. They received a pension. They got 75%. The thinking is you don't pay taxes. So that's pretty close, pretty much getting your full pay, pretty close to that. Well, they restructured that, and they made 75% now 90% of your net income. The reality of that result is, if you do the calculation, it's about a reduction of 13% in your benefit. So we reduced the amount of money that people were paid. Part of what Mr. Winter suggested, part of what was suggested in the acts that were put forward, was that it was about an affordability issue for employers. And I understand that. But the people who pay for that were the workers. And they were asked to pay lock, stock, and barrel. I go back to the deal that was done, going back to 1917 and on, and the compromise was clear. Workers were to receive compensation and have some protection and rehabilitation, and hopefully some rules that prevented accidents, and nobody was going to sue employers. And that was the deal. Well, the employers continue to have the deal that they don't get sued, but since 2002, and particularly 2002 to 2008, and a number of changes that were brought in the Workers' Compensation Act when it was amended by Bills 49 and 63, created this situation where you now have less money and less support coming. You also, as I talked about earlier, and this is a challenge, the regulation. They've invested a whole lot of power in the board of directors. In a board of directors that is essentially appointed by government, that is not politically accountable, and they get to write regulatory rules. They get to practice legislative powers, something others don't get to do. At least when regulations are written and put in place by order in council, if people want to be critical of the minister or of the government, they are being critical of people who have been elected and who can be defeated in an election, versus a board of directors at WorkSafe who is essentially anonymous for all intents and purposes to the public, and anonymous to the people who are most directly impacted by this. So I think that we need to be thinking about how we get about addressing some of those issues. As I said, you need to begin to make changes here, I think, that are broader than what Bill 9 does. And we need to make changes that will allow a more full review of WorkSafe. That doesn't take away from what's in this legislation. Some of it's very important. Some of it will provide incremental improvements as we move forward. There's no doubt about that. But we're not addressing some of the key issues that are in front of us. So one of the things that we will be looking at as we proceed, and I know that some of my colleagues will speak to this bill, and when we're back up at this tomorrow, they will be speaking to other aspects of the legislation and to what should occur here. But I think that there are a number of changes that we should be looking at and that we'll be getting to discuss with the minister as we move forward on some of these matters. We will be looking at the governance question and talking to the minister in committee about governance. We will be talking about how that board is comprised, how it's accountable, whether in fact the reviews that have been done of governance, that have been done by Mr. McAtee in a modest way. He's done a lot around the particular review related to Babine and the results of Babine and Lakeland, but what will he be saying, what should we be saying about the broader governance question, and who should be participating in that discussion? We'll be talking about compliance. We'll be talking about penalties there, and are the penalties of a nature that in fact provide real deterrence? Are the penalties of a nature that they are more than just the cost of doing business? And we know for the vast majority of employers, they will try to do the right thing, they will work to do the right thing, but not all employers are that way. And it can't simply be the cost of doing business. It's not good enough if the rules around this are such that, in fact, that's what we're seeing. We'll talk about the Crown Prosecutor and about why there hasn't been a decision taken, maybe paid for by WorkSafe in terms of the cost of a prosecutor, because we know the criminal justice branch is short of money, like everybody else, but whether in fact WorkSafe should be paying the cost of a dedicated Crown Prosecutor. That's a possibility as well. We'll talk about the issue of employer citations and whether in fact they are effective and whether employer citations achieve the objectives that we want to look at. We'll be talking about the difference between compliance agreements and rules and orders. And when does compliance agreements make sense? And when do rules and orders make sense? And does this legislation in fact get us to the place where it protects workers in a way that is firm enough to be able to accomplish that? We'll be talking about the Memorandum of Understanding and how some of that work proceeds to make sure that we end this situation that we have seen time and time again, where when there have been incidents that deserve a criminal investigation and potentially a criminal prosecution, they have not been able to proceed because WorkSafe, by the nature of its investigations, has in fact created a situation where there's so much inadmissible evidence that the criminal justice branch won't proceed. That's one of the areas that this legislation is intended to correct. And the question will be, does it create the kind of firewalls? Does it create the kind of tools that in fact lead us to be able to have some confidence that in future, when those criminal investigations and charges are warranted, that we have not compromised that opportunity because of the way WorkSafe has conducted its investigations, and we need to make sure that we are dealing with that. We need to look at I think, some of the broader issues as well in this discussion around decisions that need to be taken about what other options, what's the next step. We'll be talking to the minister in committee stage about what happens next and about what her expectations are as we proceed with changes at WorkSafe and what her expectations are. And some of that we might do in estimates process, but some of that we will do in relation to this piece of legislation because this is obviously a step forward. It's an incremental step, but it is a step forward that we'll be looking at the minister to give us some advice as to how she sees this all being addressed and dealt with. So, Honourable Speaker, I'm hoping that as we get to this discussion around Bill 9, and I'm pretty confident that my colleagues here will enunciate some of this, but I'm hoping that we also will have some discussion around some of these other issues. We may find a way to highlight some of those, whether it is the governance questions, whether it is the level of vocation and rehab programs, whether it is pensions and compensation. And we'll hear hopefully more about that from people who have many folks who are come to their offices. I know that we all, as members, get folks with WCB, WorkSafe issues, coming in to visit us or who are looking for support. Hopefully we'll get a chance to highlight some of that. Also, hopefully we get a chance to talk quite a bit about the governance role as it counts to the role, the authority of the board. I must say I have concerns about the authority of the WCB board to be able to write regulations and how that will occur, and hopefully we will get to talk about that. So, Honourable Speaker, as we go through all of this and we deal with the technical side and we deal with all of the side of this, I am hopeful that all of us in this House will remember how we got to the place of discussing this piece of legislation and having this legislation in front of us. It was about two very tragic accidents. It was about 4 people who lost their lives and the families that will be devastated forever because of the loss of those lives. It's about the other 42 people who have probably had their lives irreparably damaged by being involved in that accident. And many others that I can't even begin to understand who maybe weren't on shift at that shift or were friends or family whose lives have been rocked by what happened at Babine and Lakeland. And I know the minister is very aware of this, that at the end of the day, as we have this discussion and however Bill 9 as it proceeds and will pass, obviously, and we will support the bill, that we not lose sight of how we got to Bill 9, and that we have no illusions at all that Bill 9 solves the problem. It doesn't do that. Bill 9 is a step in the right direction. Bill 9 provides some incremental improvements, but it leaves great challenges in front of us still with worker safety. We're coming up to April 28th, which is the day of mourning. Here very shortly, there will be the annual day of mourning where we recognize workers who have died across the province, across the country. And I know that for everybody in this House, I know that's a solemn day. And it's a day that everybody reflects. And we need to make sure that Bill 9 is only a step down the road to try to make sure that there are less and less names on those lists every April 28th. Less and less people who die. Less and less people who are tragically injured and incapacitated. And we have the responsibility to make sure that those rules change, and we have the responsibility to take that task on. The agent may be WCB, but the responsibility rests here, and we can't allow that to not continue. So with that, I will close my remarks and
Move adjournment of debate.
move adjournment of debate.